Hey guys, let's see. Okay, so last Tuesday, we watched the Karen Reed hearing and it went kind of sideways. And we sat here. Bev left the bench and I could tell she was upset. I didn't have a really good understanding of what happened. Hey, Lori. Um, she left the bench and I said she's going to her chambers to scream into a pillow. I read the room. Like I knew something was going on, but I didn't quite comprehend what it was. So we're going to watch. She did come back to the bench, but the feed went black and the live view symbol that like bounces the screensaver thingy. And I thought, oh, well, they're fixing to cut the feed because that's what happens when that comes up. It means that, hey, Lynn, it means that it's done. So I was like, okay, well, I guess she's not coming back. And I stopped. And then later, um, I was texting Judy. She's here. She's just not chatting much. She doesn't feel good. Hi, Judy. Um, so I downloaded, it's only about 5 minutes when she came back to the bench. So I downloaded that and we're going to watch it.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that nation found effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check whenever?
Okay. I didn't have my mic close enough. Well, I started this very badly. I didn't have my mic close enough. Okay, so last week, Bev left the bench and she was very upset, and I wasn't quite sure what had happened. I knew it was bad, and I said she's going to go to her chambers and scream into her pillow. We missed the end because I thought they were done, and they weren't. So, I'm taking these out. I have my earbuds in. They're driving me crazy. So can you guys hear me now? So she came back to the bench. StreamYard, I hate you. So I have been bouncing around from lawyer to lawyer to lawyer trying to figure out exactly what happened. She did come back to the bench. It's only like 5 minutes long. I downloaded it, but apparently StreamYard, I don't know who hates each other worse. I don't know if it's StreamYard hates me or I'm. For some reason, the audio's not working right. It's downloaded to my computer. I was going to show the part where she came back and we missed it. I don't know why the audio doesn't work right.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
That does not. It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the
Oh, great, thank you.
Is there any way we should stay today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
I'm not.
Ma'am, just a moment.
Yes. Thank you.
Her hand, if they show it again, if she's got her glasses in her hand, you can see that her hand is shaking. She is mad. Very mad.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
Okay, so I have never seen her like that before. And, we've all been saying how biased she is. If she was really biased, can you guys hear me, first of all? If she was really biased, that should have made her happy. So, but she looked mad. Her hand was literally shaking when she took her glasses off and had them in her hand, and her hand was shaking. Okay, the ARCA witnesses, they were part of the federal investigation into this case because it was botched so badly. Things were covered up. Evidence was collected incorrectly. Things were done that shouldn't have been done, like Proctor in his text to his buddies about her medical conditions and things like that, inappropriate things. So many things were done that should not have happened, that there was a federal investigation into this case. And then there was also the Sandra Birchmore case that had some of the same cops involved with. Sandra Birchmore had gone to, I can never remember the name of it. It was some kind of a program for kids that wanted to be in law enforcement. And Sandra Birchmore was 15 years old when she began the program. It's like a camp kind of a thing. And the cops that were running it took advantage of her. And one of them, when she was a young adult, impregnated her. And she was unalived. And it was made to look like she did it herself. But since the Karen Reed trial, it got reinvestigated, and it has been determined that she did not do it herself, that the cop that impregnated her had done it. So all of these cases are related because of the troopers and cops that investigated it. And there's also another case, the Brian Walsh case. It goes to trial in October. He supposedly killed his wife, and that is also involved in the investigators of the other cases. So there was a federal investigation into all of these cases. So the ARCA witnesses they were hired by the federal government to investigate. And they are biomechanical engineers, and they're like I forgot the word. Reenactors? Not reenactors. Hey Lynn. Reconstructionist? Accident reconstructionists? So one of the theories was that because John O'Keefe had supposedly had a glass in his hand, and they were trying to figure out another way that the taillight could have been broken. Yes, reconstructionists. Thank you. And they made a cannon that would shoot a glass, and they made the cannon shoot a glass at a car taillight. They're professional mythbusters is what they are, basically. They have redesigned. See, I told you, just because needs to follow me around because he's a mind reader is what he is. He can rephrase anything I say and make it make sense. they have redesigned like the I can't speak, plexiglass in like hockey rings so that when the hockey player hits it, they bounce off and they don't get a concussion, stuff like that. So they're really, really, really cool. But what happened in the first trial, because of the federal investigation, there was a federal court order. Now, this was not Judge Cannone, it was a federal court order. They could not be prepped by either side. So neither side had spoken to them before they testified. And Judge Cannone specifically said, and I quote, "You expect me to believe that you're going to put a witness on the stand that you haven't spoken to yet?" And, "Oh, I don't know about the other ones, Judy. Oh my God. There's 2 more I didn't know about." Oh my God. And David Yannetti said, "Yes, we are not allowed to. The only thing we've talked to them about is coordinating," I wrote it down, "coordination of testimony and credentials," I think. So I listened to an attorney that was interviewed on CBS Boston and Peter Tragos and his dad. I started listening to Rob and Ian on Friday Night Frenzy, but I didn't get through all of theirs. But anyway, Lawyer, and his dad used to work for the state's attorney's office. So he says this is not a Daubert issue. Daubert is when they're not qualified to be an expert. And then you do a Daubert hearing and they get to ask questions about their credentials and whether or not they should be allowed to testify as an expert. That's a Daubert hearing. This is not Daubert. This is discovery. Because now Brennan is saying that he has these emails. First, he said the emails were given to him by the federal government. And that was when Bev left and went to her chambers. So then when she came back, then Brennan corrected himself and said, "No, I got these emails from the defense." So the defense turned these emails over to the Commonwealth. And one of them says something about a fee of $23,000. Now, on the stand, I think it was Alan Jackson. I don't know. Somebody asked one of the ARCA guys, or maybe they asked both of them, I don't remember, if they were being paid to be there. And they said no. But they gave Brennan, the defense gave Brennan an email that said something about being paid $23,000. And the thing that bothers me is that the defense didn't get up and say, well, this is why we had that email exchange. So, but I guess we're going to find out this morning what that email exchange was about. So if they did talk about some kind of prep beforehand, if they did pay them $23,000 and then they asked them on the stand and then they lied, then that's really bad. So if there was any inappropriate things going on, Alan Jackson is licensed in California. He is pro hoc vice in Massachusetts, which means that Yannetti, who practices in Massachusetts, has vouched for him to be able to practice temporarily for this trial. So Bev can take that away. If he's done something inappropriate, Bev can pull him off the case. And we absolutely don't want that to happen because he's excellent. So I don't know what's going to happen. And I don't understand why. ARCA is, you came in late, so you missed it. ARCA is, I don't remember what the initials stand for, but they are biomechanical engineers, and they work on things like one of the things they did was in like hockey rings. They developed the type of plexiglass that so that when a hockey player runs into it, they bounce off so that they don't get hurt or get concussions. So that's the kind of things they do. Like these places will call them in and ask them to redesign something, to do something in a certain way to help people to not get hurt. Or everybody around the internet, especially the women around the internet that watch the trial, call them crash daddies. They're really cute. One of them's really, really cute. There's a video that went around with actually Judge Cannone like checking them out when they were on the stand. It's really funny. But they're very, very smart. They built, because John left the bar with a glass, and they were trying to figure out if the taillight could have been broken by that glass, because they were kind of thinking that he might have thrown the glass at the car. So they built a cannon to see if they made a cannon to throw the glass, because they thought that he might have thrown the glass. So they made a cannon to throw a glass at the tail light to see if the thrown glass would break the tail light. So that's the ARCA guys. So they're professional witnesses, basically. So, oh, that's fine. I didn't have it ready to go because I don't even have my own channel up right now. Because when I shut my channel off, my video
All right. So the Commonwealth just provided the court with information that causes me grave concern.
Oh, that's not the right thing. Jeez. I need a bigger desk. You still don't hear me? I'm not muted. There's our fan. Our favorite fan in the world. The fan in the courthouse in Massachusetts. I think that's from a different angle, though. I need my boom back. Because when I had my boom, it didn't matter what position I was in, I always had my mic right at me. I just grabbed it and swung it to wherever I changed position. And now I forget that I can't do that anymore. And I will be way away from my mic until you guys remind me that you can't hear me. I like my mic. Scott, recovery addict, he explained to us one day the different kind of mics. And there's two different kinds. There's one that picks up ambient noise, like all the noise. And then there's other kinds of mic that have a sweet spot. You have to be right at the mic. And that's the kind of mic I have, which I'm glad because when my husband, we don't have a door like to our dining room and kitchen area. It's all open. There's like an archway. So when my husband's in the living room watching TV, I don't have to worry about you guys hearing the background noise as much. You might hear like a little faint background noise, but it's not like you're hearing it's going on down. But he doesn't get home till 5 anyway, so that usually only happens when we're watching a trial in a different time zone, like the corn rape trial. Yesterday I was making dinner because I'm afraid to leave because of StreamYard always crashing. But it had gotten kind of stable around like 4:15, 4:30, so I got up and I started cooking dinner. And I was back and forth between the stove and the computer. And then he came in the door a little bit after 5, and I went, shh. And he goes, I know, I was watching you. I know you're streaming. I was like, oh no, that's not good. And so every night I tell him about whatever trial I'm watching. It's like our daily routine. So last night I go to tell him about the corn rake, and he goes, yeah, I know. Remember, I was watching you. And I'm like, oh, I forgot.
You are unmuted.
22117, the Commonwealth versus Karen Reed.
Why is the sound so low?
Good
You guys hear court?
Good morning, Ms. McLaughlin.
I'm Lally Kilgama. Good
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan from the Coffee Room.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so last week, upon hearing of a previously undisclosed relationship perhaps between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There's another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Mr. Yannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense.
Your Honor, thank you for the opportunity to be heard. I am going to be on behalf of defense.
Wait, why? He wasn't even there for the first
Now,
trial.
Mr. Brennan, it's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed you, bring it up?
A court officer will take it for you.
Yeah.
I appreciate that, Mr. Alessi.
You're welcome.
I don't know. Maybe that's a better idea since he wasn't one of the ones that did something. I don't know.
And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
Yay, another break. I don't know. What do you guys think? Oh, there we go. We got an opinion.
Good morning. Extra copy of that. Thank you.
Yes, Alessi is one of her defense attorneys, but he's new. He wasn't there during the last trial. And I can understand Alan Jackson not doing it because if it is true, he's the offending party because he is the one that kept telling her not prep, didn't pay, all that kind of stuff. But I would think Yannetti would be the one to be arguing this because he was there in the first trial. So anything that Alessi were to say, it would be okay. What the allegation is in the first trial, these witnesses came out of the federal investigation. They were not paid for. The jury was not allowed to know that they came from the federal investigation. They were asked on the stand if they were getting paid by the defense. And they said no. So now these emails have come to light with an invoice for $23,000, and they came from the defense to the Commonwealth. Peter said it was a nothing burger too, but I don't know. I mean, if you ask somebody if they were paid and they say no, and then you find out that they were paid, I mean, you're lying under oath, right? Isn't that a big deal? And because he is pro hoc vice and doesn't normally practice in Massachusetts, she can throw him off the case.
I know. How to fix it. Okay. Sorry.
And it's a Jackson used to be a prosecutor. He's a defense attorney now. That's why I wanted to watch the Phil Spector trial, because he was a prosecutor in the Phil Spector trial, but he's the defense attorney in this trial.
They're right out there. They're right out there.
You are unmuted.
No, the other side too.
That's what I thought. But I don't see how it's a discovery violation. They've already testified.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
No, this was last Tuesday was the first hearing.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all, of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor, and because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you were addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes.
Yes,
Your
I
number
will tell you exact
8.
pages that I'm going to refer to. Your Honor, gets to this is tab 8,
Right.
notebook, and specific pages that I'm going to start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to suspend my
can
brief or keep going?
no, you can keep going, and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Lessie.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts. I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the document in March of 2020. As Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is, the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know, but I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep. Was not
Don't
the rule of the
filibust.
road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand.
He's such a butt kisser.
But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email. And my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript, is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial.
Karen Reed was
Do
framed.
you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only
He
the
didn't.
non-evidentiary transcripts. I reviewed.
He did not mention them
was
at
only
all.
Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts
He didn't know about them.
because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th. And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court. And it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question.
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3, and it's the June 18,
Okay.
2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement, unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on it. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolf-Qualls document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab and of course it has the
Uh-oh, crashes. Don't go anywhere. I'll fix it.
etc. I will indicate, Your Honor, that
was weird.
the information in terms of quals, etc., all of that, to me would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, but Again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments. Wolf Direct. So it's, and if you turn the page, that is the attachment, is something that has no feeling on it. I don't think anybody's going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom, is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it. It came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation, to basically say, I don't, as the court, understand. These folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right, that are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, a great deal of my work is in the field of lighting and visibility. So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No, that's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct, question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I
If
said
you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And
Okay.
I think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That.
Okay. The woman closest to the camera is one of the lawyers. That's Little. I forgot her first name. And then Alan Jackson is next to her, and there is Karen Reed. She's the defendant. And then David Yannetti is on the other side of her. The bald guy that you see in the blue shirt at the end of the table, I mean, he's not sitting at the table, he's sitting in the gallery, but you see him on the other side of the table. That is the brother of the victim. And then behind Mr. Alessi, who is at the podium, the old The older gentleman right there is Karen Reed's father, and next to him is her mother.
That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you join us and testify. Correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that the and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they had. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle. So it's important to know in terms of, you know, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, you know, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communication.
What?
But I can tell you, there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay it. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer.
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation.
So they did not bill ARCA. ARCA billed them.
Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome.
Well, no, you know what I mean. I didn't state that right.
So there's no invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, what the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's important, very important question. But it's an important fact point as well that that call was made. So in terms of the next tab, which I've been alluding to during
Okay,
my...
so this is the one I said I needed to take a recess to read
I was
that.
just going to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
You are muted.
Okay. This is the deal with the ARCA witnesses. I'm sorry. I explain things badly when I expect that other people know things. And to me, all of LawTube know about this trial. So you guys make me back up when I say something that you're unclear on. And I know that Just Because knows as much about this trial as I do, so he can help me. I know he's at work, but he can still help. Okay, so this woman went out drinking with friends and her boyfriend, John O'Keefe, who was a cop. There were other cops as well. There's an after party at a cop's house. They went to that after party. She was not sure if they were going to stay or not. She dropped John off. He was supposed to go inside, find out if they were going to stay, come back out, and tell her. She never saw him come back out, so she left. She went back to his house. They didn't live together, but she stayed there a lot of the time. He wasn't back at the house by 5 o'clock the next morning. She called a friend who was also at that party, who was the sister of the lady that owned the house. And she said he never came in. So then they went driving around looking for him. And finally, Karen said, well, let's go back by the house. And they found him on the front lawn, if not already nearly gone. So she said, could I have hit him? Because she thought maybe she accidentally hit him with the car and he was unconscious and died from the cold. So 2 of the witnesses in the trial were these biomechanical engineers, and the agency they work for is called ARCA. I don't remember what ARCA stands for. They were government during the federal investigation into the cops that botched this investigation, as well as others. Because there was a federal order, it did not come from Judge Beverly Cannone. It did not come from her. It came from the federal government, that they were not allowed to prep with them like they do with other witnesses. They couldn't sit down with them and say, this is what I'm going to ask you. They couldn't do a deposition. They couldn't, none of that. All they could say, like, work with scheduling. You're going to testify on this day, so you need to be here then, or, arrange a flight for them, or that, whatever they do. I don't know what they do. Whatever they do, that was all they could talk to them about. And maybe like vague things about their testimony, I'm assuming. I don't know, but they couldn't go in They couldn't prep the witnesses as they would normal witnesses. So, in discovery for this trial, they turned over the things they knew or the things they had from the last trial. Also, they have all the testimony and everything from the last trial. So they're not excluding them on the fact that they're witnesses, experts in their field, because that's very obvious that they're experts. They're basically professional witnesses. So yes, they are experts. So that's not why they want them thrown out. So Brennan does not have that to fall back on like he did with Dr. Russell. I don't know if you guys were watching any of the Dr. Russell testimony. She was the dog bite expert, and he tried to get her excluded and say she wasn't an expert. So she couldn't testify in this trial. But Bev said no, she can qualify as an expert and testify in this trial because they think he was attacked by a dog, but the state is saying no, that came from the car hitting him. So she's allowed to testify again. But Hank Brennan knows he cannot get them excluded as an expert witness. So now he is using these emails that were between them and the defense attorneys and saying the defense attorneys lied to you, Judge. They did talk to them, they did interview them, and they also paid them. But that is not what happened. He is misrepresenting what happened. He is making it look like they lied, but they didn't. They didn't speak to them. The emails were initiated by the ARCA guys. The ARCA guys told them what to ask. They didn't say, I want to ask you this, this, and this. The ARCA guys told them, these are the questions you need to ask us. And the pedestrian thing was one of the emails from the ARCA guy said, more pedestrians get hit at night because of visibility issues, but I won't say that if you don't want me to. So during the trial, Alan Jackson asked him that question. He did not hide that. He brought it up. Alan Jackson, the defense attorney, brought that up himself. He did not hide that. Even though the ARCA guy said in the email, I won't say that if you don't want me to. So the money thing came out of the blue. They did not know that the ARCA guys was going to give them an invoice. But Brennan made it sound like Alan Jackson had sent them a bill for $23,000.
No, tomorrow.
But that's not what happened. They got the invoice from the ARCA guy saying, you now owe us $23,000 because we testified for you. So they got in touch with the Attorney General's office asking if it was ethical for them to pay because they didn't want to get in trouble paying that invoice if it was an unethical thing to do. And they told them, yes, you can go ahead and pay them. It's fine. And now Brennan is up there with his whiny ass voice trying to make it sound like they were improper when they were not. So I feel much better today than I did after what happened last week. Did I explain that clearly? Because I guess I wasn't making myself clear earlier. And now that I know that they didn't do anything wrong, I feel like I explained it better. Did I explain it better? Yay! Yay, yay. Okay. And I wish I could redo the trial for you guys, but it was like a 3-month long trial and the new one starts in April, so we don't have time. But now, Legal Bites channel has great recaps though. If you want to get caught up, excuse me, you can watch her recaps. You should have time to watch her recaps before the trial starts. That's where I watched it. And I was a mod on her channel, and she did daily recaps, and they're really good. So you should be able to get all the details and everything from those, and it won't take you 3 months to watch it. But yeah, I cannot believe that. Like, he went point by point and answered every concern that Bev had. Now, this one that she has to look at, I don't know what it is because it seems like everything was answered. So I can't figure out. So the question, uh, oh, you asked a question and I don't. Where'd it go? The question you asked about the inverted, the lost Sallyport video. They during the first trial, they tampered with that Sallyport video. Now the defense wants the original video, and they can't get this Commonwealth to turn it over. And now Commonwealth is being stupid about these emails, trying to misrepresent what they actually were. I tried to watch. I didn't have time, but I tried to watch Olive Lawn Lumber's analysis of this. He did on Friday night. He does Friday Night Frenzy every Friday. He goes over everything that's happened in the law over the past week. And what did he say? It was funny. I don't remember how he worded it, but he said something. He said, it's the pot calling the kettle black, which I say all the time. I say pot me kettle, but it means the same thing. I was like, yep, that's exactly what I said because, he's being all shady and not giving them the video, yet he's turned around and he's actually misrepresenting things that they did right. Yep. Yep, absolutely. Oh, so yeah, Rob and Ian both, they were like, I really wanted to like Brennan. I really wanted to like him, but he's just as bad as Lowley. And I agree because one of the things he said in one of the very first hearings, he said he wanted to review all the evidence, be it inculpatory or exculpatory. And when he said that, I thought, oh, he's going to relook at this whole thing from a fair point of view. And when he does that, he might even throw it out. That would be nice to have new eyes, fresh eyes, look at it. And then now he does this. I was like, no, dude. Carla, David Yannetti started his opening statement was Aaron Reed. Because Lally, you don't want to rewatch this whole trial. Lally will put you to sleep. The man never, ever changes the inflection in his voice. And every damn question starts with what if anything. And I am not kidding. I am not exaggerating. Alita counted the what if anythings. I don't remember the final count. It was over 1,000. Every question, if anything. So if you see any jokes about what if anything on YouTube, on LawTube, that's what they're referring to. We all have what if anything poisoning. We have PTSD when you say what if anything, everybody recoils. Oh, that's good because I didn't have time to watch the whole thing. Um, they did such a horrible job with this investigation. So, okay, I need one of Brandy Churchwell's charts. The guy that lived in the house was a cop. His brother was he a federal cop? John, the guy that died, he was a Boston cop, I think. Brian Higgins, who was one of the guys, he was ATF, I think. So there's like four cops involved, and wasn't one the the brother of the cop that owned the house was like a city councilman or something. Yes, he asked who, if anyone, was driving the ambulance. He actually asked that question. I'd forgotten about that. Who, if anyone, was driving the ambulance? Oh, and you know what? What else? It was snowing. Remember that? Just because it was snowing. He asked every freaking witness if it was snowing. It was January in Massachusetts. Was it snowing? And I really thought Brennan was going to be better. I really, really did. Absolutely. 100%. And the red Solo cups that they got came from the chief of police's house. He lived across the street. Why didn't he tell them how to collect the evidence instead of just giving them his red Solo cups? They didn't know how to collect evidence in snow. It's Massachusetts. You've never had to collect evidence in snow before? Oh, thank you. Thank you. Thank you, sweetheart. Thank you. Wait, no. Brian Higgins was ATF. Brian Albert was the council person. Wait. Hold on. It's Brian Higgins. Brian Albert. You wrote Brian Albert twice, but you meant Brian Higgins. Yeah. It's just because there's two Brians. You were right. You just wrote Albert twice because there's two Brians. Brian Albert was a Boston cop. John O'Keefe was a Boston cop. See, I did it. Brian Higgins was ATF, but he had an office at the Canton Police Department for some reason. Kevin Albert was Brian Albert's brother, and he was a Canton cop. Yeah. Yeah, that's why I said I need one of Brandy's charts. She made a chart for this trial. Yeah, there's a lot of players in this, and every last one. Okay, the defense's theory, that's the one thing I haven't told y'all yet for people that don't know. They think that he went in the house and oh, well, okay. I was going to tell you what the defense's theory is. Anyway, they think he went in the house and got beat up and then they drug him outside and left him in the snow. And that their dog attacked him. That's where the dog bites come in. Okay, I will see you later. I cannot wait for this retrial. Although now that we know, I mean, Lolly played dirty, but I think Brennan is going to be worse. Because this is just downright heinous. I mean, well, inverting the Sallyport video was bad, but is this worse or just as bad? I don't know. Because he really did represent those emails as I thought that the way he represented it was that Jackson sent the emails to the ARCA guys, not the other way around. And I was so disappointed in him. I was like, no, 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 no. I had so much faith. I was like, okay, they've gotten caught with their hand in the cookie jar. So he replaced Lally and they're going to do it right this time. And shenanigans have started before the trial has even started this time. And I was also starting to think, because she was so upset about this, I was starting to think, well, maybe Bev is not as biased as we were thinking. So I was starting to give her a little bit of credit because I've never seen her that mad before. Her hand, she had her glasses. When she came back to the bench, she had her glasses in her hand and her hand was shaking. You could see her, like the arms of her glasses were like moving. Her hand was shaking so bad. And I was like, oh my God, I've never seen her that mad before. And I was thinking, well, shouldn't she be happy? If she is this biased against the defense, she can get rid of Jackson right now. She should be happy. It's like, why is she so mad? I was like, well, maybe she's not as biased as we all thought she was. She won't. You know she won't. I think that, and I've always said this, you guys have probably heard me say this before. I think if you want to recuse a judge, you should be able to bring it to another judge. Because if a judge has an interest in how a case turns out and you ask them to recuse themselves, they're not going to do it. So you think it was just that he assumed and didn't check it out, or do you think he did it on purpose? Because if he did it on purpose, there should be sanctions. But if he was just being stupid and didn't investigate the emails, then that's just a mistake. But then, if that's the case, he's not a very good lawyer, then is he? I just feel sorry for this woman. I don't know if it's because I'm a nurse and a patient, and I know how horrible her medical situation is.
You are unmuted.
And she's lost all her health insurance and all her money. And come on, straight, make it big again.
Court is back in session.
May I proceed back to the podium, Your Honor?
Please.
Would you like her to remain seated?
Come on, straight.
You can
Thank
go
you.
back.
May I continue, Your Honor?
Please.
Thank you.
Yay.
So, Your Honor, to blend and quickly summarize what we've gone through I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We talked about June 10th and statements of counsel. We talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them and we'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be, in some points, a line by line, because the words matter. Line 5, and this is again is Attorney Brennan. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased, but this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office and their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before. But his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information, so they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for, so he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next on page 57, line 11, He reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter. And unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's
Don't give him the benefit of the
relationship, and
doubt.
The Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, jury requests, and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. That's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Okay, Your Honor.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A.
I'm not rushing you. I just wanted a time frame.
Best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted. Goodbye.
Whoops, I was muted. I was muted. I was I was muted. What do you guys think? I still say he did it on purpose. I think he thought he was slick and could get away with it. I really do. I don't trust him. I don't know why. He just gives me the icks. He just does. He I I get feelings about people. I'm not claiming that I have any kind of psychic ability or anything cuz I don't. I just get the icks about people and I'm usually not wrong. And he's just one of those ickies. I like I distrust him even more than Lally. I didn't get I just didn't like Lally. He just gives me like icky vibes, like untrustworthy. And I don't know why. I don't know why he just ugh. I can't even explain it. It's just a feeling. I think anytime okay, I'm gonna go with that. I think anytime you're gonna bring something up in front of a judge, you should know for certain that you know what you're talking about. Because the judge has the power to throw you in jail. And like Law Talk with Mike says, every time there's like a pro se in front of a judge, he'll be like, if I did that, I'd be in jail. He says that all the time. So, and at first, and this is why she left the bench, Brennan said that the emails came from the federal government. And then he corrected himself when she came back and told her, no, it wasn't from the federal government. It was from the defense. I got the emails from the defense. So right there tells you something. If it was improper, if those emails were improper, why would the defense turn them over? They would have been hiding them, right? Or trying to hide them. And I can see now why they had Alessi argue. Because at first I was like, but he wasn't even there. But that makes it better because he's impartial. He wasn't there. He wasn't a part of it. He can do his own like little his own independent investigation and then say, Judge, I looked into this. I wasn't a part of it. And this is what I found to be true. So you've got Hank arguing on one side who was not a part of it, and you have Alessi on the other side that wasn't a part of it. Yeah, they both have an interest either way, yet they were both not a part of it. So, I mean, they're not impartial, but they were both not a part of it, so they can do their own little investigations and figure out what happened. I didn't read this before I put it up. I hope you behaved, Dardo. Yes. Yes, the prosecution has to be slime balls on this one. They for sure know the facts and that they do not support their case. Still, they push forward in an unholy crusade to convict an innocent woman. Well said, Ardo. Well said. And I don't know why, other than trying to not implicate other cops. But if cops are corrupt, go ahead and implicate them. I don't understand. Well, there is nothing wrong in paying an expert witness. They're professional witnesses. That's what they do for a living. That but that's not what would have made it bad if they paid them. What would have made that bad is that on the stand Alan Jackson asked them if they had been paid and they said no. Therefore, if there's an invoice for $23,000 that was paid, yet they said on the stand that they were not paid, then that's a lie. However, that invoice came way after the trial. Well, maybe not way after, but it came after the trial. So at the time that the question was asked, they had not received an invoice and no payment had been made. So at the time that the question was asked and he said no, that's not a lie. And Alessi went through every single question that was in question and said what the question was, what the answer was, and said true or fact or whatever. None of them were lies. And all of those emails, like the questions, yeah, that would be so nice. That was one thing when I was a nurse. I was always terrified I was going to get pulled into a trial somehow. I mean, it would have been cool, but if I had been pulled into trial as a nurse, I could have been in the hot seat, and I didn't want that. I had two coworkers that had to testify in a trial about something, and they were never allowed to talk about it. So I never knew what happened. Like, I didn't know the story of what happened. They could only say, oh, that stupid case. And they had to do something. I don't remember if it was every year or every 2 years, but they had to, like, some kind of class or lecture or something they had to do because of it. So I don't know if they did something wrong. Because they could never talk about the details of the whatever happened. I don't want that to ever happen to me. So I was always afraid that something was going to happen. So what I did, if anything happened that might come back to bite me, I would take a page of nurse's notes and I would write down exactly what happened right then. And I would take it home and put it in my file cabinet and keep it just in case. So I would have everything written down exactly, because when you write something in a nurse's note, like in a chart, you can only write certain things. So, you can't write if you had an argument with a patient's, well, in the nursing home, it would have been the patient's children. You can't write that in a nurse's note. I mean, you can, but you got to kind of sugarcoat it. So I would write down, I would take out a nurse's note and I would write exactly what happened, and then I would keep it. So, because I've been threatened by some children, adult children of elderly patients, over stupid stuff. You have no idea. So, cover your butt. But yeah, I don't trust Brennan. I had such high hopes at the beginning, and then now he just gives me the icks. I don't understand why they're railroading this woman. What good does it do? Like, who is really involved? We don't know, but we suspect Brian Albert, maybe Colin Albert, or maybe more likely Colin Albert, and Brian Albert maybe helped. Because what are the theories? Colin Albert was dealing drugs, maybe, and John O'Keefe knew about it. Because if you remember during the trial, they kept saying that Colin had already left, but somebody slipped up and said something about Colin and John being at the house at the same time, and then they like backpedaled on the stand. I can't remember who that was. But everybody, and almost in like in an angry type of tone, everybody was like, no, Colin had left before John got there. Colin and John weren't at the house together. And then, remember when Alan Jackson put up the pictures of Colin with all his scraped knuckles? And then he read the text and stuff where Colin said all this stuff about effing people up and liking to fight and all that. So that's one of the theories, that Colin started a fight, and either they were in the basement, and that either he fell and hit his head because there was like a gym down there. Either he fell and hit his head on a weight, or Brian Albert hit him in the head with a weight. That's just a theory. I'm not saying that's what happened. That's just one of the theories. And that Chloe, the German Shepherd, jumped up and attacked him because he was fighting with Colin. So he was trying to save Colin. So the marks on his arm look like a dog attack, and it's just the right arm. Now, there is one guy, I can't remember his name. He testified in the Alan Murdaugh trial, and he says that they don't look like dog bites. They look like they're a continuation from wounds here over here. So, like, he got his arm caught under the car or something, and that made the wounds, continuing wounds, go from here to here. But I've seen that one guy that Melanie Little had on her channel, that was he trains like police dogs, and he had one of those fake arms that they put on the guy, and those wounds on that fake arm look exactly like John O'Keefe's arm. Well, there's speculation that they were lying about that. The timeline, everybody's timeline does not fit. And now they're saying that there's video of Brian Higgins at the Canton Police Department, because that was weird, the time of night that he went to the police department after he'd been out drinking. This whole case is just such a mess. There's not a good solid timeline. People are saying different things, and the whole thing with was it the EMT that insisted she heard her say, I hit him, I hit him, I hit him, and then asking about her being friends with Allie, and her denying being friends, and then the Facebook photos that they were friends and all of that crap. This is just the most absurd, messed up case I've ever seen. Now, I've seen some strange trials, just because, like, strange red rums, like the Zachary Hughes case. That was bizarre. But this is strange investigation. This is botched investigation. This is, and I'm not a conspiracy theorist type of person. And when Yannetti got up there and said Karen Reed was framed, I was like, yeah, right. Because, but when they got to the red solo cups, I was like, okay, dude, I believe you now. Because who does that? Even people that have never been involved with law enforcement and they watch cop shows, they know you don't collect blood evidence in a red solo cup. Administrative work. Moving cars is administrative work. Yeah. Yeah, exactly. Yeah, he was wasted and he moved vehicles at the police station. Sure, he did. It's crazy. It's this whole thing is just so insane. Yeah, because they're not really cousins. They're kissing cousins. And I need a chart again. I gotta think. I might blow a gasket trying to figure it out. Okay, let me see. Allie. Are they back? Why is there noise but the lights are out? Why are the lights out? No, the lights are on, but why is it so dark? The lights are off on the camera. I'm confused. What is happening? That's weird. Colin was Chris Albert's son, right? So he was Brian Albert's nephew. And Allie was Jen McCabe's daughter. And Allie, so that made Allie Brian's wife's niece. So they were cousins by marriage, not by blood. Right? Did I get that right? Yes, I remembered. I got it right. Yeah. 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 So they're cousins by marriage, not by blood. So it's possible. They were best friends, supposedly. But I don't know why the EMT felt like she had to lie about her relationship with Allie. Because that made it look more suspicious. She could have just said, yeah, I know Allie. A small town, they went to high school together. Just, yeah. Why? You could, two things can be true at once. You could still say, yes, she said, I hit him, I hit him, I hit him. And you could still say, yes, I know Allie. I know, me too. That's why I was like, oh, I gotta think. I'm gonna blow a gasket, but I have to stop and think. There's just too many players in this that are all related to somebody somehow. But small town, that's the way small towns are. Um, I live in a small town, and unfortunately, I have a lot of relatives that have died. We have cardiac issues in our family. I'm fine. I've had my heart thoroughly checked out. I'm fine. But a lot of our family's already gone. But I remember years ago, I went into the bank and I guess the lady at the bank thought I was my cousin's wife instead of his cousin. And she's like, when is he going to come in and get his card or something? I don't know. And I was like, I have no idea. And then she realized she asked the wrong person and she's like, oh, I'm sorry. So, yeah. And then there's always the who are you related to? Are you related to so and so? Yeah, it gets old fast. Believe me, it gets old fast. And then after I got married, I missed it. And I was like, man, I wish I'd hyphenated my name. That's why my name is on everything except Face and Cook because, um, man, I wish y'all would hot mic in the courtroom. Damn it, there's nothing else on. So, I wished I'd hyphenated it, but I left it on. It became that on YouTube because that's what it was on Facebook. And somehow, whenever I made my YouTube account, that's what I put my name. I never picked a name.
A little warmer. I love it.
Yeah, okay,
So
on that.
it became Debbie Face and Cook, and then I shortened it
I guess I should go, right?
Debbie F Cook because I
Oh,
wanted
yeah,
people
you
to be
can
able
go.
to find me that know me.
Yeah. I'm gonna, definitely.
My pastor, so funny because he knew me forever, and we had stopped going to church for a while. So when I started going back, I was married, and he knew me through Facebook. So now he calls me Debbie Face and Cook every time he sees me. How you doing, Debbie Face and Cook? I'm fine, Pastor. Thank you.
Oh, did they say they wanted more like other shots too?
Just you, I'm looking again, but you just, definitely just ask for her.
It's hard. I was trying to do that. We for like a window of pause or something. I could go into something, but like they keep saying stuff, and I'm like, they're gonna say the good thing, and I'm gonna be like,
I've never heard that song.
yeah. So all the defense counsel is right here.
Yeah.
And then the guy that's kind of presenting his case is here.
Yeah.
We have autoimmune crap in our family.
You worry about
Karen
Karen
Reed's family is here.
Oh, okay.
We've had a couple of
like,
cases of cancer, more than a few. I'm the only one with lymphoma, and I tried to.
Yeah, I usually start out with the judge and then just kind of follow the football.
It's driving me crazy. Why is there a hot mic? Stop. So, why? What movie is it from? I'm not my live streams aren't monetized yet. Kids movie about. I'm gonna Google. What was I just gonna say? I am so tired about hearing about the new Harry Potter movie and I mean TV series and oh, that's the name of the movie? Wait a minute. This says it's a Willie Nelson song. Okay, I'm gonna have to check this out. I love Tom Arnold. I used to watch, what was it called? Dang, I forgot the name of the show. My Big Fat Redneck Vacation. That's what it was. The first show he did was called My Big Fat Redneck Wedding. It was like a play on my Big Fat Greek Wedding, that movie. And it was so funny. It was just a bunch of redneck weddings. And um and then he started doing one. My husband got me hooked on this show. I go and I'm like, what are you watching? And it was this family. What they did, they put out an ad for a family that likes from the country that likes to do things like four wheeling and fishing and hunting and basically people like me. And come on, Streamer. So I go in there, I'm like, what are you watching? And he's like, he's laughing his butt off. I'm like, what are you watching? He's like, oh, you have to watch this. Come watch this. So Tom Arnold was like the host or MC or whatever you call him. And they had rented this house. I guess it was like an Airbnb, and they were on vacation. And I missed the first part of that season. And it was out in the Hamptons on Long Island. Grandpa Jones. And there was a storm. They call them northeasters up there, but they're like hurricanes that we have hurricanes down here. And they had chickens. I don't know why they had chickens, because like I said, I missed the beginning part of the season. They had chickens. I guess they bought chickens somewhere and they set up a chicken coop, but they're in the Hamptons. And the one woman was waking up her husband in the middle of the night. They're like, go get the chickens. Bring the chickens inside because it's storming out there. Bring the chickens. It was so funny. So it was like they were all related. It was like 3 or 4 families and they had their kids. And it was just so funny. And then they made friends with some women in the community. And so they invited them over for a tea party, for like a real afternoon tea party. Now, if you guys don't know the difference between Southerners and Northerners, we have tea parties. We drink sweet tea all the time. And we don't call it iced tea, we call it sweet tea. We don't drink it hot, and we don't drink it with cream in it. We drink iced tea full of sugar. And we don't call it iced tea, we call it sweet tea. So they go over for this tea party. They do not have a clue what they're doing. So they go in there and they sit down with these ladies, and they have this little cup of tea with a saucer, and they're looking at each other like, what are we supposed to do with this? And they take a sip and put it down, and one of the ladies like, are you guys okay? Is there anything we can get you? And one of them goes, can we have some ice, please? We don't drink our tea hot. And he goes, oh, really? We were worried about it getting cold. I'm like, no. Well, do you guys need any cream or sugar? Sugar? Cream? No. No cream. It was so funny. And the whole season was like that. And then the next season, They rented for them, I can't remember, it had to be at least two RVs. And they took them all over the country, but in like weird places. So in Florida, I did not know this, but in Florida, there is a hippie community, and some of the hippies are nudists. That was absolutely hilarious. And then some of them wanted to sleep in the RV. So when they went back to the RV to sleep at night, it was filled with a bunch of nude hippies. It's just, it was so funny. They went out to Monument Valley, to the Indian reservation, and they did, I don't remember what it's called, where you get in the teepee and then you um they burn coals and it's like steamy and then hot, and they smoke that peyote or whatever it's called. They did that. It was just all, it was all weird stuff, one after the other after the other after the other, and just, it was such a good show. Oh, they went out to Las Vegas, and there was a couple that renewed their vows with a wedding, with a Elvis impersonator in Las Vegas. It was just anything that was out of the ordinary that they could find for them to do, they did. They went to South Beach in Miami and got Botox shots. The women did. It was just, it was so much fun. I loved that show. It only lasted 3 seasons. The third season they went to England, and that's, I kind of got bored halfway through that because they stayed in this castle and they weren't allowed to do anything. There was a butler. They weren't even allowed to go in the kitchen and like make themselves a sandwich. They had to ask the butler for everything. And that was the point that I was decided I was out. I was like, no, this, it's stupid now. They can't even go make their own sandwich? I don't think so. But Tom Arnold was hilarious on that. Like, he didn't go with them, but he was like the narrator or whatever, like that was explaining what they were doing. And then um I can't think, it was a second season. They had like an after show where they asked the people questions and they would show outtakes, because you know reality shows aren't really reality, they're scripted. So they would show things that got cut out, like because they would tell, you know, like they would do something and they would get a reaction, and they would say, no, you can't react like that, you got to do something different, and then they would reshoot. So it was funny. So I liked Tom Arnold back then. I haven't seen him in anything in forever. That was, I don't know, that was probably around 2010 or so, because Travis and I got married in 2007, and we still had TV back then. So between 2007 and 2010, because we don't have TV anymore, we just have streaming services. She's not going to be back till 2. I've run out of things to talk about. Why did Long Con just go dark? Oh, they're back. What are they doing? They just have the test screen image thingy up now. They had the courtroom up a minute ago with the hot mic. That's why I muted it, because it was driving me crazy. Oh no, that. We don't need a squeal. I can't wait for this trial to start. I think the reason why it's not the corruption that I want to see corrected. It's, I mean, I want to see that corrected, but it's like if that can happen to her, it can happen to anybody, and it's scary. And I mean, I know there's innocent people in prison, but usually, I don't know. I don't know the statistics, but it seems like usually it's false confessions. And this one is not that. This one is just corrupt cops. And that in itself is an injustice. And then you've got the Richard Allen situation, which is bizarre. I don't know if that's corruption or not. That might just be poor judgment because they put him in solitary for his protection. And then he went crazy and confessed. And so then at trial, he gets convicted because he made a confession. And because nobody got to watch that trial unless you were there, we don't really know what happened. And so, like, everything was sealed. Documents were sealed. Things weren't allowed to be mentioned in the trial. I don't even think they talked about the Odinism aspect, which a lot of people believe is what happened. I don't even know what Odinism is. And I don't even know if it's a cult or a real religion. I have, and that is something else that I am very unsure of because I believed his innocence 100% after watching that. And then watching other things about that later, now I'm curious as to whether or not Netflix spun that to make it seem like he was innocent. But the question I have is why would he do that after being exonerated of the other thing? I mean, wouldn't you think that would be the last thing he wanted to do is go back, really do something to put him back in there? Like, that would be so stupid to do. Yep. But see, that's what I'm saying. Is it, to some people, that's real? So is it a cult or is it a real religion to some people? That's just, I don't know. I'm just saying, I don't know. I guess if you have to sacrifice somebody for it, it's a cult. I don't know. I could be wrong. I don't know. Because I don't know anything about it. I just know that that's what that was going to be his defense. And then they said he couldn't use that defense. The one thing, though, Jilly Bean, I will tell you, I think his nephew got railroaded because he's autistic or something. He doesn't have the capacity to make good decisions, and he was questioned without an attorney. He was told to sign a confession. like he told the cop something, the cop wrote it down, and the cop told him to sign it. No parent, he was a juvenile, no parent, no attorney. I think he got railroaded. I really, really do. And the cop implied if he would just tell him what happened, he could go back to school. So I don't think that Brendan Dassey should be in prison. Some type of punishment, but not prison. I don't think he had the mens rea to do it. He didn't do it independently. He did it because he was told to do what he did, and then he was not given the support to defend himself afterwards. The Depp v. Heard documentary on Netflix, I won't even watch. Number one, because they used a bunch of YouTubers' material without asking permission. That's the main reason I won't watch it. And number two, because I heard that it does not depict things in the correct light. And I am so sick of people saying, I'm so sick of people saying that, you know, Johnny Depp lied and he was a wife beater and whatever. I watched the whole trial, and I think I'm a pretty good judge of people lying. She tried to cry and couldn't. She even, I think, everybody that said that they thought she was doing coke on the stand, I think she had something in that tissue that to try to make her cry. I don't think she was that brazen that she was snorting coke on the stand. I think she had something in there, like, I don't know what, but something to make her eyes water to try to make herself cry. I think she was trying hard, but she's a horrible liar. And then her acting coach, I was like, this is why they don't let witnesses watch trials before they testify. I get it now. She said in her testimony that that was a problem that she had, was crying on cue. And I was like, that is hilarious. Because Amber was trying so hard to cry and she just couldn't do it. And now her acting coach just confirmed she can't cry on cue. That's perfect. But yeah, and now this Blake Lively garbage, I don't care. I don't want to cover it. I don't give a crap. The only thing well, I was going to say the only thing I hate is that she's taken Ryan Reynolds down with her. But from what I'm seeing about Ryan Reynolds now, he deserves it. So I liked him until all this crap happened and I found out apparently he's just as rude as she is. So I don't know. I'm to the point that I don't give a crap about celebrities. They're not any better than we are, and we're the ones that make them famous. And if they can't honor that and be nice to us, then screw them. And one thing that I have learned from the way things are nowadays is that the best way to let something or somebody know that you're upset with them is to hit them in the pocketbook. Like, look at Bud Light. Look at how their commercials have changed since Dylan Mulvaney. Everybody didn't like Dylan Mulvaney, so they lost money. And now Shane Gillis is in their commercials and they're making money again. So, money. Hit them in their pocketbooks. That's what you do. Don't yell. Don't scream. Don't complain. Don't go on TikTok, Facebook. Just quit giving them money. It works every time. Yeah, I'm worried about Richard Allen. Although that poor man has probably totally lost his mind by now. He's going to end up back in solitary. I said on um, Court Vibes, we were talking about it, and a lot of people disagreed with me. But, they put Daryl Brooks in Supermax in Colorado, in Florence, Supermax. Everybody there is in solitary. And I said, I don't think it's right that the person that got attacked, they put him there because he got attacked. And I said, I don't think it's right that they're being put there for their own protection, but actually they're the ones getting punished when all that happened was they got attacked. So now they have to stay in solitary forever just because they got attacked. And Kathy was like, you know what? I don't care. He mowed down a bunch of people with his SUV during a Christmas parade and he didn't care about them. Well, yeah, that's true. That's absolutely true. But do we need to make his mental health worse because of that? I don't know what the solution is. Oh, I'm not comparing them. I'm not, because I don't know the specifics. So I can't compare because I don't know the specifics. The only thing I'm comparing is that they're both celebrities. Yes, Depp did admit. He did. Which is why it made me love him even more. Because who gets up there and says, yes, I do this, I do that, I do this, I do that, and then try to defend themselves against somebody else? Right? Like, he was totally honest about everything. Even the text with between him and Paul Bettany. And then some people don't like him now because of those texts. I'm like, they were joking around. They were talking, there was Monty Python references. And they were like, yeah, but you don't talk about your spouse that way. I'm like, so what? I have a very irreverent sense of humor. I saw a whole bunch of thumbnails that said that Baldoni had won in court. And I don't know what they're talking about because I haven't been following it. I just keep seeing thumbnails. That's all I know. And Alita was on Spidey's channel, but I didn't watch it. I usually watch his videos. He did a Blake Lively one before. I don't know. It might not have been before. It was before I became aware of all the Baldoni stuff. And she did an interview. Oh, I already told you, guys. I told you this the other day when we were talking about it. She did the interview with her and Parker Posey. That was on Spidey's channel. She was rude to the interviewer. I don't know if it was before the Baldoni stuff, but it was before I had heard about the Baldoni stuff, and Spidey didn't mention it. It was just purely about her being rude to the interviewer. But I think it was last Saturday he did an episode and Alita was on there, and I haven't watched it yet because I don't care. And I didn't watch Alita's episode about it either because I just don't care. I only like Ryan because of Marvel. And I also saw some thumbnails that said that Marvel fired him. I don't know. But I'm so tired of franchises firing people for stupid things. Warner Brothers fired Johnny Depp when he didn't do anything, yet they kept Ezra, stupid ass Ezra. Did they ever release the Flash movie? I still want to see it. I don't want to pay money to go see it, but I want to see it. Because I want to see Batman. I want to see the Batmans. Okay, so which came first? The Flash with all the Batmans or the Spider-Man with all the Spider-Men? Batman, Spider-Man, Spider-Man. I don't know. It bombed. Of course it did. Ezra screwed it up. I swear this country has a mental health crisis. What? I don't know what we're going to do. I really, really don't. Well, I'm a huge Harry Potter fan. And when I watched the first Fantastic Beasts movies, I had forgotten who Grindelwald was. Because he's in the books, he's not in the movies. So I had the hardest time trying to figure out why he was such a big deal and what was going on. My biggest thing at the end of that movie was, oh my God, that's Johnny Depp. That's Johnny. Oh my God, that's Johnny Depp. That was exactly what I did. And I got my kids there, and my husband's on my one side, my girls are on the other, and I'm like, you guys, that's Johnny Depp. That's John Depp. Freaking out in the theater. But I'd forgotten about Grindelwald. And he did? I don't remember that. Oh, I remember what I was saying a while ago. I saw something else on my phone about fans are upset about the new look of Voldemort for the new HBO Harry Potter show. I'm so tired of people complaining. So tired. It's like everybody's, yay, there's a new Harry Potter thing. And now they want to nitpick at every little thing. Do you want it or not? If you want it, shut the F up. Well, he didn't do anything wrong and they cut him from the movie. There is a behind the scenes thing. I can't remember if it's on the DVD. I think it's on the DVD. There's one line in the second movie, and they asked, I think it was his idea. He says it 4 different ways. And he asked the director which way he wanted him to do it. And he goes, I don't know. Just do it all the different ways you want to do it, and then I'll pick the one I want. And he did it 4 different ways. Each way he did it makes the line have a different meaning. And I was just in awe. He is the best actor I think that we have of our generation. And I just felt like that was the worst thing in the world for them to take him out of that movie. So that upset me. And then I saw an interview with, I either read an article or saw an interview with Ezra Miller, because when he came back for the second movie, after all this stuff came out about Amber Heard and everything, Ezra Miller was upset because he was like, well, no one consulted us and we didn't want Johnny Depp to come back for the second movie. Of all people to be complaining about somebody, Ezra Miller was upset because they kept Johnny Depp on for the second movie. That ticked me off. I was like, dude, you have no right. Oh, yes, Mads did an excellent job. I did not have a bit of a problem with his portrayal at all. And Johnny Depp liked his portrayal. He loved it. He had nothing bad to say about it. He, like, there's no sour grapes between them. I saw a picture of them hugging at a film festival after the movies was made and released and everything, and I screenshotted it. I have it on my phone. I kept it because I was like, that's just so cool. So there's no hard feelings between them or anything, and the portrayal was great. The one thing though that I didn't like was that they didn't explain it. Although they're wizards, they can change their appearance, right? But there was no explanation, and I felt like maybe he should have said like, well, I had to change my appearance because they're looking for me or something like that, and there was nothing like that. Well, I think that was maybe something the fans wanted, because I think that was the problem with the first movie, is that people wanted it to tie back into Harry Potter more. Because I've heard people say, well, I don't even like the Fantastic Beasts series, and I think that's why the second and third movie wanted to tie back in more. I think Jude Law does a really good job playing Dumbledore too. Um, character though is wrong because the timeline doesn't work out at all. She shouldn't be there, but they did that for the Harry Potter fans too, and doesn't work. She's too young to be there then. So I can't wait to go to Epic Universe. Just because, have you been to Universal, to the Harry Potter stuff? I cannot wait to. They're supposed to have a Ministry of Magic ride, and it's Dolores Umbridge's trial, and she tries to escape, and you're supposed to be capturing her or something. So I can't wait. I'm so excited. I'm going to have to get an annual pass again, though, in order to get a ticket, because it's not going to be open to the general public for a while. You have to have an annual pass to the other two parks in order to buy a ticket to get into Epic Universe. So. Oh, wow. I don't think I've been there since 2023. Doesn't seem like it's been that long, but I think it's been since 2023. I'm jonesing for some butterbeer bad. Which is why I lost the weight and why I wanted to get monetized, because I don't have the money to go anymore. And I couldn't fit in the rides. I got down to where I could fit in them, and then I gained the weight back and I couldn't fit anymore, and I was like, this is not happening. I have to be able to fit on my broom. Couldn't fit on my broom anymore. It's so much fun. I love it. So the Ministry of Magic ride looks like it's going to be fun. And then it's also going to have part of the Paris Ministry of Magic. But I don't think there's going to be any more rides. I think that's going to be the only ride. So, and I have to get another Pygmy Puff because my Pygmy Puff doesn't make noise anymore. Ouch. She used to coo. Or he. I don't know what gender it is. It's got like a box inside of it, and it would coo when you squeezed it. I squeezed her too much, and the battery went dead. They have them now where you can remove it and replace the battery, but apparently they didn't have them when I bought her. Or him, whatever. You can hear it click, but no purr anymore. So I have to get a new one where you can replace the batteries. I have bedroom slippers like this too. The tops of them have a Pygmy Puff on them. I have a wand. I have a lanyard for my Harry Potter pens. I'm a huge Potterhead, y'all. Wait till I get my new studio set up. If my daughters will come get their crap out of that room, it's going to be all Harry Potter. I've got my Star Wars over there, but it's going to be all Harry Potter. Okay, Bev, it's 2. I also have to take my wand and get them to check it because it doesn't work, or it didn't work last time. Which I thought it was me being incompetent at spells, but I think my wand is broken. It's cool with the Hogwarts Legacy game. When you learn a new spell on the screen, it's the shape of the spell, the way the wand goes, but there's buttons that you have to push. The little cursor thing on the screen goes, and at certain points in the shape, you push A, B, X, Y, whatever button. And I noticed right away, that's the real way you wave the wand for the spells. Because at Universal, at the Wizarding World, you at the shop windows, there's a little gold circle, and it has the shape of the wand, the shape of the spell, the way you move your wand. And I don't have them all memorized, but I do recognize some of them. So on the game, I'm like, oh wow, that's the real way you move your wand for the spell. I was like, that's so cool. I like Lord of the Rings. I'm not crazy about Lord of the Rings. My 3 big fandoms are Star Wars, Star Trek, and Harry Potter. If I had to pick just one, I would have a really hard time between Harry Potter and Star Trek. I would be fine without Star Wars, which you wouldn't be able to tell by coming in my house because most of my decor is Star Wars. Oh, and Disney. Yeah, I'm a huge Star Trek. A lot of times when I'm watching a trial and there's an attorney that's just hammering on the same topic or the same question over and over, and they can't get the answer they want, I'll go, there are 4 lights. And people will go, what are you talking about? It's like, it's a Star Trek reference. Star Trek reference. But yeah, you know those giant like desk pads, like gaming mouse pads, they take up the whole desk. Mine is the Enterprise D. I just got it the other day. It's the I don't know why. Like I said, Star Trek is one of my favorites. I don't have Star Trek memorabilia. This is the first one I've ever had. I don't have shirts. I don't have cups. I have everything else of my all my other ones. I don't. I don't know why. I just don't. I need to start collecting Star Trek stuff. I want there's a cup I want. It's a heat one of the heat change ones, and it looks like they're being beamed up when you put hot liquid in it. I want that shirt. And the Star Trek shop has Quark's bar glasses. I want those. There's lots of stuff I want. I just haven't got them yet. I did. I like to diamond paint, and I got a Star Trek D. I mean, an Enterprise D diamond painting, but it didn't look good because one side of it looked like it had been in a fight, and like I didn't know if it was supposed to look that way or if I did something wrong or if it was just a bad print or what. So I was like, dang it, I was gonna frame it, and I was like, sure, Ardo. Yeah, sure. I'm not seeing that one. That's great. That's great. I love it. That's good. Yeah. Um I always say that TNG is my Star Trek because that's the one I didn't grow up watching, but like it started I was late teens, I guess, when it started. Um when I was a kid, my brother watched the reruns, and I hated Star Trek because there was one time he was babysitting me and I wanted to watch Cinderella, the musical, the old one with Leslie Warren, like the old um, Rogers and Hammerstein one. It was on TV and I wanted to watch it, and my brother wouldn't let me because he wanted to watch Star Trek. So growing up, I hated Star Trek. And then I um I have fibromyalgia, so I took a leave of absence at work, basically going to doctors and stuff trying to figure out what was wrong with me. And then while they were figured it out and put me on medicine, and I was trying to get things under control so I could go back to work, I found on Comedy Central they used to show the original series, and they would do things like every time Kirk would fight, they would be like, rip shirt incoming in one, like in 3, 2, 1. And they were like, they would make like funny observations about the tropes and cliches of Star Trek. And I watched it like that, almost like it was a comedy. And it kind of got me hooked. And I already had liked TNG. And then I started watching them. And then I started watching Deep Space Nine, and I was like, oh my gosh, this is like soap opera. And then after that, I was hooked, and it was like, oh no, I'm a Trekkie now. I'm no going back. I can't believe I used to hate this show because I love it. Love it. So TNG is my favorite. Yes, absolutely. Picard is the best. Absolutely. And have you seen Picard, the new show Picard? The third season where they're all back together is like amazing. So good. And there's lots of Easter eggs back to TNG. It's just they did so good. The only thing that I didn't like about it was that Will Wheaton wasn't in it, but he was briefly in season two, briefly enough to explain why he wasn't in season three, but still. Okay, Bev, it's after two. Shut up, Wesley. Shut up, Wesley. um, Will Wheaton does that thing on YouTube. It's called The Ready Room. The only thing is that you will get spoilers from the shows, but he does a really good job interviewing people from the shows and talking about them. It's really, really good. Yeah, Voyager's good too. The only thing about Voyager is that now that it's all over with and you know about the things that happen behind the scenes, I mean, if you can keep from thinking about it, it's fine. But I don't like what's her name? Janeway. What's her real name? Forgot her name. Because of the way she treated Jerry Ryan, who is a sweetheart. She's such a nice. I mean, I've never met her in person, but she seems like she's such a sweet person. And basically, um, she was treated badly because she thought it. What is her name? Janeway. She was like, well, this is my show. I'm the star, and now I'm being overshined by Jerry Ryan, and I don't like it. And she treated her like crap. So none of those shows have a star. They're ensemble shows. They're ensemble shows. There is no one star. And you can't be that way. Like, and also, oh wow, I have not seen that. I love Will Wheaton. I loved him on The Big Bang Theory too. Yeah, it's Catherine something. I just can't think of it right now. I mean, yeah, you have a lead because there's a call sheet, but still. And then, well, Shatner did the same thing on TOS too, because Leonard got Mulgrew, yes, because Leonard got more fan mail than he did, and he became a diva, and everybody hated him because he would take lines away from them and all kinds of stuff. So he did the same thing. I'm sure he's not a very pleasant person in real life. All right. What is happening? I hate it when this happens. See, last week. This week got different. U symbol. Jumping around this week, we have. Well, if it'll do it, come on. I like the little test pattern thingy. But she said she'd be back at 2. Can't get it to pull back up. Come on, StreamYard. I don't have anything else running. Anything else? I went on my Wi-Fi app and I shut off anything else. It was going to Wi-Fi. The only thing connected is my computer. I don't think I ever saw Red Dwarf. I did see Babylon 5. I used to like the one where the spaceship was live. I can't remember the name of it. Was it Andromeda? And I liked Firefly too. And Stargate. What is going on?
You're talking about to me.
Oh yeah, the Orville's really good. Orville's kind of like an homage. Oh yeah, Seth MacFarlane is a really big Star Trek fan, and he was in Enterprise, only in a couple episodes, but he was in that.
Have it?
Yeah, I have a copy.
You are unmuted.
We're back in session, maybe see.
All right, Mr. Leslie, why don't you go ahead and continue?
Thank you, Your Honor. May it please the court. I first want to thank Your Honor for the generous amount of time you're according
Need to thank me. Just go right ahead, sir.
But kiss her.
And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan, substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote, and it's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," and he's quoting accordingly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications, that's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery?
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth,
okay,
providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. 2 Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay, what time of day? Because if it's California time, it might be different than what we have here, but
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay,
And
go right
so-
ahead.
And so it would suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's just
If we can, I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
It is that, may I ask Your Honor, if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. Clark.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question.
He corrected
So-
himself though.
So we move on to page, so there we have on page 58, we have another incorrect statement. We have 2 of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer, Your Honor, now. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you're, thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
So
Subject-
that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualify the expert. Is this all one document?
No, Your Honor,
All right,
and I appreciate the question.
What
So-
is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one?
The
When
other
that
one was
sent?
sent the day before on June 22nd.
Okay.
I'm just gonna give it the name that the email has. I think it's wolf_quals document, okay? So there's 2 emails, one's just the quals, the other, I respectfully, Your Honor, I know what you're calling it. I'm just gonna call it what it says, and the title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. There is an accounting on the face of the emails that I
Let me
just
actually
went.
hold that thought. I just have one other thought. about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you are
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That, I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, but blah, 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 blah. Now here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago, 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, et cetera, et cetera. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have. I agree. It would have been, and you did. Twice. Next. Reading on the same page 16. He's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh, and I went back and watched the video. Shh, don't tell them. I'm sorry? What do you mean don't tell them? You were told twice, in the voir dire and in the direct. In the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, nope, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry. There's another point at the no. Let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases, I've been around the federal court a bit, I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made, sometimes parties pick sides, it creates blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than an illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpreted it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and frankly of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, the court saying the break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit. None of
In this case?
No,
Or
I'm
just saying
talking-
generally, you've had this issue in other cases, or do you mean? this
other
case?
cases, other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, you know, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds onto the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute. I made a mistake. A significant mistake. My whole predicate for my whole presentation was I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARPA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARPA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. buried in a chronology is, in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent us the emails and the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14, what was not corrected? It wasn't corrected that the invoice came from the defense. Just the emails.
I thought it meant everything, but.
I don't understand how that conclusion can be drawn, Your Honor. You didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get it precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this, being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page up to the federal government again, because I was curious about the change in position on February 6th, that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it, because that would naturally preclude the defense from retaining them, yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for my side. That's the way I took it, and I appreciated that, because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize your honors giving us that week, and we try to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up something.
You don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to Model Rule 3.3A1.
Tread carefully, Alessi.
Every counsel in this room,
You're
of course.
doing great, but tread
A
carefully.
lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. This court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like, you make a misstatement, it happens, but you know, you got to correct it, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false, of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page are you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with? No, okay, I received it. I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. McAuliffe, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court, move to exclude the witnesses? Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right, last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson. This is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it with other sides seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided, the federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the clause, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here. And I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is, unfortunately, a woman attorney was in a bad divorce. She had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it. I didn't remember it. I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect of, and I went through all the others that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate, Mr. Jackson's eliciting of the direct testimony at trial when he asked, have I ever asked you specific, questions, etc. That's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18. Obviously, the Commonwealth is in no position to contact, etc., etc. And what does that relate to?
If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry. Okay. So my point is, we produced the discovery.
I think she's over it.
Why is there still an issue with ARCA? These aren't my words. So I want to cover.
I think
before
you
get
should
to
quit
the
while you're
situation,
ahead, Alessi.
the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme
Counsel pro hoc vice, or was that?
I'm gonna get to that. The answer is the counsel. I want to be sure of my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated, but the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted, and it wasn't a revocation of pro hoc vice. There's a difference.
There is
Obviously.
a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive get more than repetitive, but go to things that are done, that are corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong, literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive. I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued state scrutiny of the defense counsel. And I don't say this a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we made mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Brunetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can, and certainly can. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
You are muted.
We're in recess.
He is certainly thorough. I did like how he started that, though. Sorry, I'm writing a letter to Judy. I'm almost done. Um, I like how he started that. I typed in chat. What did he say? Um, Dang it. I typed it in the chat. Counterfactual. Counterfactual. Oh, let me show him to you, Judy, before I put him in the bag. Look, his ears are squished from being in the bag. Ta-da. There he is. What do you think? And if you push his little feet in good, he'll stand. Oh, you can't see him now because the camera's too low or too high. Well, no, you still can't see him. Well, he'll stand if you push his little feet in. He's the first one I've been able to make stand. All the others, you had to prop him up against something. But he's all done. Yeah, I like the counterfactual. I was like, that's nice. That's a good way to say lie and sound diplomatic. I'm losing people. Is this like super boring? I'm sorry. I had to watch this. I was heartbroken last week because I was like, no, Alan Jackson did not do something skeevy. Absolutely not. I was not going to believe it. I had to hear their side. And one of the things that upset me so terribly was that they didn't stand up and say, no, Judge, that's not right. So, no, you didn't do anything. It's just stuff about the channel. But unless he made the point, they weren't given time to stand up and say, no, that's not true. They really weren't. Why does YouTube reject the most banal comments? All I said was I would love to see Brennan's face right now. And YouTube rejected it. Because there has been no cameras on Brennan at all. And I really, I'm egg on his face right now. He did correct himself. When Bev came back to the bench, he corrected himself because he did say he got them from the federal government. And then he corrected himself and said, no, he got them from the defense. But he didn't correct himself that the invoice came from ARCA. He made it seem like it was sent from, like, the defense was like, I will pay you this. This is what I'm going to pay you because you testify for us. He made it sound shady. And I've never been in awe of a lawyer before. Well, Camille Vasquez, maybe, but Alan Jackson is just, I don't know. He's just really good lawyer. And you know how, like, some people that are really good at their profession, you just get like this, they can do no wrong type of opinion about them. I mean, everybody makes mistakes, but like, they're not going to purposely do something wrong. And I was just, that's why I was like, I have to see this hearing today. We have to wait on the other trial. I have to see this today because I was like, no. He didn't do anything wrong. He couldn't do anything wrong. He absolutely couldn't do anything wrong. Yeah, it was a very tiny correction very late on, absolutely. But somebody said, and I don't remember who it was, it might have been Peter, that he knew darn well that he had made a mistake and he better correct it. And that was the only reason why he corrected himself. So, but see, now Brennan looks shady. Whereas last week, I didn't think he was the shady one. I thought the defense team was being shady. So, I don't understand. Is it because I'm an honest person that I don't understand what the big cover up is? They're cops, so what? If it was an accident, it's not like they planned. I hate this because I don't know what words I can use and what I can't. Because YouTube changes their minds about stuff every other day. And, if you're far enough into a live stream, you can say stuff that you can't say early on. And also, I don't want to accuse people of stuff. It's going to get so much harder now that I can be monetized. I haven't set it up yet. And I sent Alita a DM on X asking advice, and then I realized she's not going to tell me because she's going to say, I can't give you legal advice because I want to put it in Travis's name. And I don't know if I can do that or not. Anyway, they didn't mean to unalive him. If the defense's theory is what happened, they didn't mean to unalive him. So, why didn't they just call 911 and say he fell and hit his head? Like, why all the cover up? I got quieter because I'm being, what's the word? Thoughtful, reflecting on the situation. Um, why didn't they just call 911 and say he fell and hit his head? And then maybe now this would happen. They could have got him in the hospital in time. Like, why all the secrecy and cover up and all the middle of the night butt dial crap? I don't understand. The whole thing is so weird. I don't understand. So much could have been done differently. But like Carla was asking earlier about his injuries. No injuries from the neck down other than his arm. And I know I keep saying this, and I'm just one person, but I was a nurse for 17 years. I've never seen a motor vehicle accident, a pedestrian hit, or a passenger or a driver that has no injuries whatsoever on their lower extremities. Never. 17 years. And I don't know how you get hit by a car and have no damage on your lower extremities. Especially how far Trooper Paul said that he was thrown. However, Trooper Paul's physics is, it just is. So his account is not exactly reliable, but I still don't see how he has no injuries unless he was literally like, if he was standing and literally bent over at an angle like that and she backed up into his head. I don't see that happening. She would have had to hit, if that was a thing, she would have had to hit him hard enough for him to go flying away from the car. So then how do you explain the arm? None of it makes sense. The explanation that makes sense is that he was in the basement and was in a fight. The dog attacked his arm. He either fell or got hit in the head with a weight, and then he was dragged out of the house and left in the snow. That explanation makes perfect sense. Hit by a car, not so much. And the ARCA testimony is key. And she can't exclude them on expert status because they are absolutely experts in their field. There's no way to get them excluded. So this was Brennan's little brainstorm on how to get them excluded, and it blew up in his face, I think. But we'll have to see. Of course, she's not going to make a decision today because that's her MO. She always says, I'll take it under advisement. So maybe I misinterpreted, because remember I said she was mad, but she should be happy about this. Maybe she was mad because she knew Brennan was being shady and that it was all going to come out that Brennan was making stuff up. And of course, this is all speculation on my part. I'm just thinking out loud because I feel sorry for this woman. I don't think she did it.
All right, so before I open the call, Mr. Leslie, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week, but actually, what I want to do, you said I could ask questions of other counsel. So while memories are fresh, I just want to show the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Unetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Leslie? And what I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after the transcript.
No,
I did as well.
no,
after
no.
I looked at the
I
transcript.
did long before I went to that.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about being frustrated about for his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is.
Nope, hold on. Ms. Little, it's just thrown on you that you're, that you're responsible for all discovery. But the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Britton.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Britton.
She's gonna let him talk for 15 minutes. Did she just say they're ending at 4?
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct of this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves
Projection.
to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations at the sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know. A voir dire is inconsequential. I don't know what to ask. I can't send them back on records or the emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. there is a murky relationship between the defense and the United States Attorney's Office relative to these ARPA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARPA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARPA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask.
After your request that I do that, Mr. Lisi.
It wasn't a request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. The first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARPA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth a motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial, and it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro act. We have one licensed attorney in Massachusetts. who's carrying 3 Pro-Hog BJA attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully to Attorney Yannetti, fine attorney, an excellent attorney who I admire, but there is a responsibility so that there are not a number of Pro-Hog BJA lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read this discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through 2 requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've got.
May I have a moment to speak to counsel?
Sure.
Thank you, Mark.
I'll need to call the United States Attorney's Office and give an answer.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies at the 24 saying the U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board there was asked, were you available to the Commonwealth? And the witness said yes.
Dude, have you not been paying attention? They didn't email them. ARCA emailed the defense. What were you doing? Have you been sleeping all day?
I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024. discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's Dave, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing.
Karen is so disgusted right now.
Presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, this is June 10, 2024, trial transcript 28.
Hold on one second.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing.
court asks, well, I thought that you would
Page,
help.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up. Page 4, line 11, the court asks, so the understanding of the voir dire is that if this is for the Commonwealth's motion to exclude this testimony, all right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rensler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked in the court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARC are wholly independent from each other. This is also consistent with their representations regarding payment. There are questions, voir dire, and a trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024, that's addressed to.
Hold on 1 second, please. Okay.
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Lisi takes today, is this was a blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. Our experts knew. Dr. Wolf knew. Dr. Enchler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, so they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office. 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9th, 2024 phone call. Another participated telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about their potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then its expenses from June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and court never knows about. Talk about correcting a record. And so This $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6. Motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asked Mr. Jackson about paying the bill. And what I suggest more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions, and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at the report, and I'm not going to read it for the sake of the press and the public, we'll have a trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they...
Particular page you'd like to look at without citing?
If you look at the first page.
Yes.
Yeah,
You don't have to read any of it, you just tell me what paragraph.
I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, tentatively, but also a trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly there is a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the author clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the art experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get 14 material. It has been my effort not to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, and I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to provide testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just hope that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about me is what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
No.
go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Khan?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony. And let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting Steele about which ARCA witnesses, because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unity, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
Page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true, because I
read that earlier.
Right, but Mr. Brennan just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard and got the order, because that's the first she knew of the inquiry, she gets the order, I said, turnover discovery. When you read it, she said, no, I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.38. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor, which said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diazzi. It involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where defendant or choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said it'd be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brown?
Very briefly. My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed late, right?
February
Or
6th.
Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Minetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not,
Ms.
right?
Little has
It's
only done the
maybe
certificate of
authored
service.
by, okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Minetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Danny Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Lisi no longer likes the word retain, but that retain word has import. The reason he said their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
Yeah, I don't think Alessi knows how to be brief, or that's his definition of brief. I don't know. Okay, guys. Tomorrow is my nerd block. So what we're going to do is we're going to catch up on the corn rake trial tomorrow. Whenever I get home, I'm just going to go live and we're going to get caught up on what we missed today. So I'll see you guys tomorrow. Bye.